On January 30th, 2026, the United States Department of Justice did something unprecedented. They broke a federal law in broad daylight, held a press conference about it, and told the American people they'd done nothing wrong. This isn't about Jeffrey Epstein. This is about what happens when the institution responsible for enforcing the law decides the law doesn't apply to them. The conversation right now is focused on the wrong thing. Everyone's talking about who's in the files. Trump, Clinton, Musk, celebrities, billionaires, politicians. That's the designed distraction. The real story is happening in the mechanics of how these files were released, when they were released, and why half of them are still missing. Here's what you need to understand. The Epstein Files Transparency Act wasn't a request. It was federal law. Passed by Congress with a vote of 427-1 in the House. Unanimous in the Senate. Signed by President Trump himself on November 19, 2025. The law was simple. The Attorney General had 30 days to release all unclassified files related to the Jeffrey Epstein and Ghislaine Maxwell investigations. No exceptions for political sensitivity. No exceptions for inconvenient timing. 30 days. That's it. The deadline was December 19, 2025. On that date, the DOJ released 12,000 documents, out of 6 million pages they acknowledged having in their possession. That's not even 1%. For 6 weeks after the deadline, they kept saying the files were coming. They blamed the volume. They blamed privacy concerns. They blamed the review process. Then, on January 30th, 2 months late, on a Friday at 4 p.m., they dumped 3.5 million pages and walked away. If this sounds familiar, it should, because this is exactly how powerful institutions operate when they don't want you to see something. They delay until the pressure becomes unbearable. They release everything at once so nobody can process it. They do it on a Friday afternoon when media attention is lowest, and they frame it as compliance. But here's the question nobody in mainstream media is asking. If they had 6 million pages and only released 3.5 million, where are the other 2.5 million? Let me walk you through what actually happened, because when you see the timeline, you'll understand this wasn't incompetence. This was strategy. November 19, 2025, Trump signs the law. The 30-day clock starts ticking. The DOJ has until December 19 to comply. December 19, 2025. Deadline day. The DOJ releases 12,000 documents. Congressional members from both parties immediately call this a violation of federal law. They're not wrong. The law didn't say release some files. It said release all files. December 20 through 23. 16 files that were briefly available on the DOJ website suddenly disappear. No announcement, no explanation, just gone. Members of Congress demand answers. The DOJ stays silent. Early January 2026. The DOJ sends a letter to Congress confirming what everyone already knows. Less than 1% of the required files have been released. At this point, polling shows something remarkable. 91% of Democrats want full release, 78% of independents, 74% of Republicans. This is one of the only issues in America with near universal agreement across party lines. January 21, 2026. Democratic Congresswoman Summer Lee introduces an amendment to hold Attorney General Pam Bondi in contempt of Congress for violating the transparency law. It fails on a party line vote, 19 to 24. That vote matters because it establishes a precedent. Statutory deadlines are now optional if your party controls the majority. January 30th, 2026. 72 days after the legal requirement, the DOJ dumps 3.5 million pages, 2,000 videos, 180,000 images. Deputy Attorney General Todd Blanche holds a press conference. He says the department is now in full compliance. He says the review required 500 attorneys. He says victim privacy was the priority. What he doesn't say is why half the files are still missing. Within hours, something interesting happens. Journalists start analyzing the files and discover that the redaction software the DOJ used was faulty. You could literally copy and paste the blacked-out text and read what was hidden. People started doing this, and what they found wasn't just victim names. It was investigative findings, FBI intelligence, details about Epstein's network that the DOJ clearly didn't want public. Within 48 hours, Congressman Ro Khanna points out the obvious. The DOJ said they had 6 million potentially responsive pages. They only released 3.5 million. He demands an explanation for the missing files. As of today, he hasn't gotten one. Now, let me explain why this matters from a legal perspective. Because if you understand how prosecutors think, you'll see exactly what's happening here. When someone is legally obligated to produce documents by a specific date, and they don't, prosecutors ask 3 questions. First question: did they have the documents? In this case, yes. The DOJ admitted in writing they had 6 million pages before the deadline. Second question: did they have the capability to comply? Yes. They assigned 500 attorneys and staff to the project. They had 2 months before the deadline to prepare. This wasn't a resource problem. Third question: what changed between the deadline and when they finally complied? This is the important one. Between December 19th and January 30th, several things happened. Congressional pressure increased. A contempt motion was filed. Public polling showed overwhelming bipartisan disapproval. News organizations started investigating the missing files. Then, only after the threat of formal contempt became real, the files appeared. That's not compliance. That's coercion. And here's what prosecutors look for in cases like this. They look at what was released and when. The DOJ's own press release about the files includes a statement defending Trump. They specifically say some claims in the files about him are untrue and sensationalist, and were submitted right before the 2020 election. That's political framing of a legal requirement. It tells you the DOJ was concerned about more than victim privacy. They were concerned about narrative. The law had exceptions. You could withhold information to protect victims. You could withhold classified material. You could withhold evidence related to ongoing investigations. But nowhere in that law was there an exception for politically inconvenient information. Nowhere was there an exception for missing deadlines. And nowhere was there an exception for releasing only half the material. So the legal question is simple. Did the DOJ violate the Epstein Files Transparency Act? Based on the plain text of the law, yes. The remedy? That's where it gets complicated. Because who enforces the law when the enforcers break it. Here's what they're not telling you. This isn't about Jeffrey Epstein. This is about whether statutory deadlines still mean anything in America. Think about the precedent this creates. A federal agency misses a legal deadline by 2 months, releases only half of what the law requires, faces a contempt vote that fails along party lines, and declares victory. If that's acceptable for the Department of Justice, it's acceptable for every federal agency. The IRS can miss tax deadlines. The FBI can ignore FOIA requests. Immigration services can delay citizenship applications indefinitely. Because if the DOJ can do it, everyone can do it. The Epstein Files Transparency Act had something almost nothing in Congress has anymore: genuine bipartisan support. It passed 427 to 1. That means Democrats and Republicans agreed this mattered. The public agreed. Polling showed 70 to 90% support across all political groups. But when the execution happened, something broke. The DOJ resisted. They delayed. They released a fraction of what was required. And when Congress tried to hold them accountable, the contempt vote split perfectly along party lines. That tells you something. It tells you institutional loyalty overrides legal obligation. It tells you political calculation matters more than statutory compliance. And it tells you the system of checks and balances only works when people choose to make it work. Earlier in 2025, Attorney General Pam Bondi said a client list from the Epstein investigation was sitting on my desk right now. By July, the DOJ announced no such list existed. By January, the files were released with heavy redactions and missing pieces. What changed? The DOJ's story changed, but the public's distrust didn't. By January 2026, polling showed that nearly half of Republicans, 3/4 of independents, and 90% of Democrats believed the government was still withholding information. That's not a conspiracy theory. That's a majority of Americans across the political spectrum saying they don't trust their own government on this issue. And when the files finally came out, the DOJ released them with a statement emphasizing that some claims about Trump were false. That's not neutral administration of a transparency law. That's political management of a legal obligation. Here's the hidden calculation. Every day those files stayed unreleased was a day the executive branch controlled the narrative. Once they're public, they belong to everyone. Journalists can analyze them. Researchers can cross-reference them. The story fragments into 10,000 pieces, and nobody controls it anymore. Delaying the release was delaying that loss of control. The question prosecutors ask in cases like this is, who benefited from the delay? And the answer is, anyone who appears in those files and has influence over the agency releasing them. This has implications that go far beyond one case. When the Department of Justice fails to follow a federal statute, who holds them accountable? Congress tried. The contempt motion failed. The courts could intervene, but someone would have to sue. And even then, the remedy for missing a deadline after you've already released the documents is unclear. The House Oversight Committee separately subpoenaed Attorney General Bondi for unredacted files. She hasn't complied. The same committee subpoenaed Bill and Hillary Clinton to testify. They refused. The committee voted to hold Bill Clinton in contempt, 34 to 8. 9 Democrats joined Republicans on that vote. For Hillary Clinton, the vote was 28 to 15. So now you have competing contempt claims. Congress says the DOJ is in contempt for missing the deadline. Congress says the Clintons are in contempt for ignoring subpoenas. And nothing happens to anyone. That's not a functioning system of accountability. That's a system where legal obligations are suggestions and enforcement is political. The DOJ is supposed to be independent, insulated from political pressure. But when the president who signed the transparency law is mentioned in the files, and the DOJ delays the release until threatened with contempt, and then releases them with a statement defending the president, the appearance of independence disappears. Deputy Attorney General Blanche said there was no White House interference, but the optics tell a different story. A Friday afternoon dump, 2 months late. A press statement highlighting false claims about the president. Whether or not there was direct interference doesn't matter. The appearance is enough to destroy trust. A CNN poll from January 2026 found that only 6% of Americans were satisfied with the government's handling of the file release. Not 6% of Democrats, not 6% of Republicans, 6% total. That means 94% of the country thinks something went wrong. That's not a political problem. That's a legitimacy crisis. So where does this end? The DOJ says they're done. 3.5 million pages released, case closed. But congressional Democrats are demanding explanations for the missing 2.5 million pages. Victims' advocates are criticizing the release for exposing survivors while protecting powerful people. Journalists are using software to recover redacted sections, and the House is preparing contempt votes that likely won't result in any real consequences. Meanwhile, the precedent is set. Federal agencies can miss statutory deadlines. They can release partial compliance and call it complete. They can frame politically sensitive releases with defensive statements. And as long as they control enough votes in Congress, there are no consequences. This moment isn't about Jeffrey Epstein's crimes. Those are documented, proven, settled. This moment is about what happens when the agency tasked with enforcing the law chooses which laws apply to them. Watch what happens next. Because the next transparency law, the next congressional deadline, the next statutory requirement will be measured against this moment. And if this is the standard, there is no standard. Institutions don't collapse in a single moment. They erode slowly. One missed deadline, one ignored subpoena, one party line vote at a time. And by the time people realize the system isn't working anymore, it's already too late to fix it without breaking something else. The Epstein files are out. Half of them anyway. But the real story isn't in those files. The real story is in the 2 months it took to release them, the 2.5 million pages still missing, and the fact that the institution responsible for justice decided the law didn't apply to them. That precedent matters, not just for this case, for every case that comes after. This moment matters.